Hello and welcome to the first episode of our new video series called Real Estate Law Essentials. In this series is dedicated to helping property purchasers, homeowners, and investors better understand their rights and the key legal issues they should know when navigating real estate transaction in Ontario. To start the series, we're joined by Master Zangene, barrister and solicitor, and principal of Zangene Law Firm Professional Corporation. Mr. Zangene is an experienced Ontario lawyer whose practice focuses on real estate law, corporate and commercial matters, wills and estates, and uncontested family matters. In the first episode, we are gonna discussing a foundational topic, the different types of joint ownership in Ontario, and what every property purchaser should know about their legal and practical differences. Masood, thank you for joining us and for helping us launching this educational series aimed at empowering buyers and property owners with valuable legal knowledge.
Thank you so much, Ali, for inviting me, and I'm happy to talk about some of the most important items or topics in real estate law for the audience.
Thank you very much. So let's go and start with the questions. First of all, when two or more people buy real property in Ontario, what are the possible forms of co ownership?
Um, we have two different types of co-ownership in Ontario and pretty much in the whole country, with simple differences. These two major co-ownership types or capacities uh, are called a joint tenancy and tenancy in common.
Okay.
Joint tenancy is um, has different consequences than tenancy in common. I'm going to talk about that in details later when you ask other questions.
Thank you very much. I have that question coming up next. So, what are the key differences between joint tenants and tenants in common?
The key differences are for joint tenants, the shares of the partners have to be exactly the same, equal. So it means that if there are two partners, it has to be 50-50, or
Oh,
three
I see.
partners, 33.3%. It cannot be different shares. And it has
Mm,
to be created at the same time. It means that there is a unity of time that the right has been created. So it cannot be one of the partners join later and has the same right. No, it's not possible. It has to be created at the same time with the equal shares. About tenants in common, you don't need to have equal shares. You can have different shares, and it doesn't matter if they want to be created at the same time or later on. It doesn't matter. So there is no unity of time of creation. On the other hand, joint tenancy has a survivorship right.
mm,
It means that whoever dies, if one of the, let's say, joint owners die, the share of that deceased person is going to be transferred over to the surviving partner. Um, that is one of the tools that we usually use in estate planning. I'm going to explain it later in the estate planning section. On the other hand, joint tenants, there is no survivorship right. It means that if the one of the joint owners, if one of the owners die, that his or her share is going to go through his or her estate. So it's not going to be transferred to the other partner. So these are the key differences between joint tenants and tenants in common in practice.
So when it goes to a state, it's going to cost them, no?
If it goes to the estate, definitely estate has to pay estate administration tax. So that is 1.5% of the estate over
Mm.
$50,000. So if the estate is, let's say, 100,000 on the first 50,000, there is no estate administration tax. On top of that, there is 1.5% state administration tax. So when the share of the partner goes to the estate, definitely land transfer tax has to be paid on that portion of the share. But in joint tenancy, when the share of one of the partners who is deceased is transferring to the other, the surviving partner, there is no estate administration tax. So
Okay.
this is kind of ways that can save some taxes for the beneficiaries or for the state.
Thank you very much. Let's go to the next question. How can joint ownership be used in estate planning?
So when we usually do estate planning, we are using some tools, different tools for estate planning. Estate planning, in simple words, are it is planning for the future of your asset and estate. It means that you are preserving your estate for your beneficiaries or for yourself if you are alive or and for some reason you are not able to decide about your asset.
Okay.
Let's say you are mentally incapacitated. So you want to preserve your asset for yourself and for your family and your estate. It's called estate planning. And estate planning has different tools, like will is one of the most important tools we use for estate planning, powers of attorneys, trust agreements or trusts, life insurance, and even joint ownership is one of the key factors and key tools that we usually use for estate planning as well.
Thank you very much for this detailed information. Next question. Can a partner easily change one type of ownership to the other one?
Yes and no. When you want to change the ownership from joint tenant to tenants in common, it's easily possible because only the person who decides to do that needs to have consent about it. So with one consent, it can be done, and the joint tenancy can be severed and separated. But tenants in common needs the consent of all of the joint tenants, all of the owners, in
Mm.
order to be severed. So, simple question for joint ownership, joint tenancy. It is possible, and it's very simple. For tenants in common, it's not that simple.
Okay, thank you. So let me check the next question that were asked. What happens if a joint tenant partner becomes bankrupt or sells his or her shares?
Um, if a joint tenant becomes bankrupt, the tenancy or joint tenancy will be, the joint ownership will be severed automatically into tenants in common. It means that if it is joint tenant, when one of the partners become bankrupt, it becomes tenants in common automatically. Um, Also, if one of the partners sell his or her own share to somebody else. Let's say me and you have a property, joint owning a property, and ownership is joint tenants. So if you sell, you can sell your own share to somebody else, to a third party. Anytime that you sell it, the joint tenancy terminates or severs and it becomes tenants in common. And if something happens to one of the partners, the share of that partner is not going to be transferred to the other one. It's going to go to his or her estate.
Okay, thank you. So, and the last question for now is how do you recommend the spouses, business partners, common law partners, and family members get the title?
Um, it is different for everyone. Let's say for spouses, if they don't have or didn't have any previous marriage and previous children, so usually they take the title as joint tenant because they want the other partner to become the whole owner of the property if one of them dies. But for common law partners and business partners, it might not be the case. Or the spouses who had previous marriages and they had children from previous marriages because they want if something happens to them and they die, they want their share goes to their children, not to their new partner. So any case is different. We usually advise our clients who are closing, or they have real estate closing, they are purchasers. We are advising them to be careful about picking and choosing the title of the ownership because the consequences are totally different and might be disastrous for their beneficiaries and family members.
Okay, thank you very much. Anything you want to add for this episode before we wrap up the
Um,
video?
Not that much because there are lots of things about joint ownership, but the basic information that every purchaser needs is they have to figure out if something happens to them, what would be the consequence of the joint ownership or tenants in common ownership. They have to think about it in advance because it can be can make some difficulties or even deprives some of the beneficiaries from the asset and state of that person, which it can have different huge consequences. So it's better to think about it before it gets late.
I see. Thank you very much. So I guess that's the estate planning part, huh?
That is no. It is actually it's for the time that they're taking the title. They have to think about if they are, let's say, there are two people or three people. They have to think about it. We have a questionnaire for the purchasers at the time of closing, before closing actually. They fill out the form and there is a bold section talking about differences between joint ownership, like joint tenancy and tenancy in common, if there are two or three or more partners. So, and I usually personally explain it to purchasers about the consequences of choosing each of them. So this is something that is at a time of purchase of property you have to consider. Then, at the time of estate planning and preparation of the wills and other documents, I review their, ownership types or the capacity they took title at the time that they purchased a property. If whatever they have matches their desire and their wish, so they keep it. Otherwise, they change it. So I usually ask them at a time that I am talking about all of the elements of their estate planning, like will, powers of attorney, and everything. I discuss this matter as well. And if they, because most of the partners at the time that they purchased the property, they never understood that there are two different types of co-ownership, and they never chose this. By default, some of the lawyers, if they see there are spouses, they register their title as joint tenant,
Joint tenant.
which is not good, because if they had previous marriages, they might want to reconsider this. So this is very important. They have to know what they are doing. Yeah.
Amazing. Thank you very much, Masujan. Uh, Thank you for watching this first episode of Real Estate Law Essential with Masu Zangane, barrister and solicitor at Zangane Law Firm Professional Corporation. We hope today's discussion on the types of joint ownership in Ontario has helped clarify the key legal differences between joint tenancy and tenancy in common. If you have any questions, let me put the barcode there. If you have any question about this topic or any other matter related to real estate law, you can reach us any way you think that it is good, and you can use that logo there. Reach us using our new WhatsApp group with the same name. Link is there at the
At
top.
the other
Oh,
side.
that side, the other side. Okay, so until next episode, that we are gonna cover another important legal session. And thank you very much. And I'm Ali Bulurci, and this has been Real Estate Law Essential. See you next time.
Thank you.
Thank you.